So how can a country just close off a vital international strait and create such a global stir? What's the legal angle on that?
Well, this comes from an interesting analysis by Dr. Dumoli Agusman, and he's looking at the Strait of Hormuz situation with Iran. The strait is super narrow, only about 21 nautical miles at its tightest, and it handles like 20 to 30% of the world's oil trade. So it's a huge deal.
Okay, so it's a critical choke point for global energy. But what about the law? Does the UN Convention on the Law of the Sea, UNCLOS, even apply here?
Right. UNCLOS does have a framework for straits used for international navigation, which the Strait of Hormuz clearly is. It connects parts of exclusive economic zones or the high seas, and it's been used for international shipping for a long time.
So it's covered by UNCLOS. But Iran hasn't actually ratified UNCLOS, has it? Doesn't that mean they're not legally bound by it?
That's exactly where the legal debate starts. Iran signed UNCLOS in 1982, but never ratified it. Under international treaty law, a treaty usually doesn't create obligations for a third state without its consent.
So if UNCLOS doesn't bind them, what about customary international law? Do other countries argue that this transit passage is now a custom that Iran has to follow?
Many argue that the transit passage regime has evolved into customary international law, which would bind Iran regardless of its UNCLOS status. This view is based on widespread state practice and even the Corfu Channel case from 1949.
But then there's this persistent objector principle. Could Iran claim that status and avoid the customary law since they've always rejected the automatic application of transit passage?
Precisely. Iran has consistently and openly objected since the UNCLOS negotiations, stating they would only apply innocent passage based on the 1958 Geneva Convention. They also have a 1993 law requiring prior permission for warships and submarines, and they've made official statements and diplomatic protests.
However, if Iran has allowed ships to pass unhindered for years, wouldn't that undermine their persistent objector claim? It sounds like tacit acceptance.
That's the counterargument, that Iran's practical action allowing free passage could be seen as tacit acceptance. This could erode their persistent objector status, making them subject to the customary norm of transit passage.
And what about during wartime? UNCLOS seems to be designed for peacetime, but the article mentions it doesn't clearly address wartime situations.
Yeah, UNCLOS was negotiated in a peacetime context, so it doesn't really specify what happens during war. In such situations, the law of armed conflict at sea, like the San Remo Manual, applies, allowing coastal states to take actions against enemy ships while still respecting neutral vessels.
So it sounds like there are strong legal arguments on both sides. This isn't going to be resolved easily then.
Exactly. International law lacks a centralized judicial authority to force a resolution without the parties' consent. So the interpretation and enforcement ultimately remain political and diplomatic, influenced by power dynamics and state practice.
A very complex situation indeed. It highlights how much international law relies on agreement and diplomacy, doesn't it?